Every day, your business collects information about people, names, emails, the pages they click. One European law reset the rules for how all of that has to be handled, and its reach extends far beyond Europe's borders. In the next few minutes, we'll break down the GDPR in plain English, what it is, who it touches, and what it actually asks of organizations. GDPR stands for the General Data Protection Regulation. Its formal name is Regulation, EU, 2016/679, and it's the European Union's flagship law on data protection and privacy. It was adopted on the 14th of April, 2016 and became enforceable on the 25th of May, 2018. If those two dates feel far apart, that was deliberate. Organizations were given a 2-year runway to get ready. GDPR didn't appear from nowhere. It replaced the older Data Protection Directive from 1995, a set of rules written before smartphones, social media, and cloud computing reshaped daily life. Because that older law was a directive, each country implemented it a little differently, which created a patchwork of standards across Europe. GDPR is a regulation, which means it applies directly and consistently across all EU member states. For businesses, that consistency was meant to be a benefit as much as a burden, one clear standard across the whole European market, instead of dozens of national variations to track. The goal was simple to state and ambitious to deliver: give people meaningful control over their personal information, and hold organizations accountable for how they use it. Here's the part that surprises many people. GDPR is not limited to companies based in Europe. It applies to any organization, anywhere in the world, that processes the personal data of people located in the EU, as long as that processing relates to offering them goods or services, or monitoring their behavior. Scope isn't about your nationality or your company's size. A small startup and a global platform are judged by the same test. In plain terms, what matters is where the individual is, not where your servers or your headquarters sit. A software company on another continent that signs up European customers, an online shop that ships to the EU, or an analytics tool that tracks European visitors can all fall within scope. This is what people mean when they call GDPR extraterritorial. It's also why so many privacy notices and cookie banners around the world changed around 2018. Organizations everywhere recognized that European users were part of their audience. So what counts as personal data? Broadly, it's any information relating to an identified or identifiable person. That obviously includes names and email addresses, but it goes further. Location data, online identifiers like IP addresses, and account numbers can all qualify if they can be linked back to an individual. The word processing is broad too. It covers almost anything you can do with data, from collecting and storing it to sharing, analyzing, or deleting it. GDPR also says you can't process personal data just because you happen to have it. You need a lawful basis. There are 6 of them: consent, contract, legal obligation, vital interests, public task, and legitimate interests. Consent gets the most attention, but it's only one option among several, and each carries its own conditions. On top of a lawful basis, the regulation is built around 7 core principles. Data should be handled lawfully, fairly, and transparently. It should be collected for a specific purpose and not repurposed loosely. That's purpose limitation. You should collect only what you actually need, which is data minimization. Information should be kept accurate, and not stored longer than necessary. It should be protected with appropriate security, integrity and confidentiality. And finally, accountability. Organizations are expected not just to follow these rules, but to be able to demonstrate that they do. One of the biggest shifts GDPR introduced was a clear set of rights for individuals, often called data subjects. People have the right to access the data an organization holds about them, and to have inaccurate information corrected. They can ask for their data to be erased, popularly known as the right to be forgotten, though that right isn't absolute. They can restrict or object to certain processing, and they can request their data in a portable format to move it to another provider. There are also protections around decisions made solely by automated systems, without human involvement, when those decisions significantly affect someone. Together, these rights shift the balance so that individuals aren't just passive sources of data. Rights on one side create obligations on the other. GDPR asks organizations to build data protection into how they operate, rather than bolting it on afterwards. A few duties stand out. Many organizations are expected to keep records of their processing activities under Article 30. For high-risk processing, they may need to carry out a data protection impact assessment, a structured way of identifying and reducing privacy risks before a project goes live. The regulation also promotes data protection by design and by default, privacy considered from the start, with the most protective settings applied as standard. In practice, these duties push privacy out of the legal department and into everyday decisions about products, vendors, and systems. Then there's breach notification. When a personal data breach happens, organizations generally have to notify their supervisory authority within 72 hours of becoming aware of it. If the breach is likely to put people at high risk, the affected individuals should be told as well, without undue delay. Some organizations also need a data protection officer, an independent expert who oversees compliance. A DPO is required for public authorities, for large-scale systematic monitoring of individuals, and for large-scale processing of special categories of data, such as health or biometric information. GDPR carries real weight because it has real consequences. Enforcement is handled by national supervisory authorities across the EU, and fines come in two tiers. The most serious violations can reach up to €20 million, or 4% of a company's total worldwide annual turnover, whichever figure is higher. That "whichever is higher" wording matters, because for a large multinational, 4% of global turnover can dwarf €20 million. The point isn't to frighten anyone, it's that regulators were given tools proportionate to the size of the organizations they oversee. The largest single fine so far came in May 2023, when the Irish Data Protection Commission issued a penalty of €1.2 billion against Meta over unlawful transfers of personal data from the EU to the United States. Cases like that are the exception rather than the everyday reality, but they show the ceiling is genuine. If all of this feels like a lot, that's understandable. GDPR is broad by design. In general terms, organizations tend to start in the same place, understanding what personal data they hold, where it came from, and why they have it. That exercise, often called data mapping, tends to surface the practical questions everything else depends on. From there, common next steps include reviewing the lawful basis for each activity, tightening privacy notices so they're clear and honest, and making sure there's a process to handle people's requests and report breaches on time. It also helps to keep a simple record of key decisions, so that if a regulator or a customer ever asks, the reasoning is already written down. None of this is about perfection overnight, it's about being able to explain what you do with people's data and why, the accountability thread that runs through the whole regulation. If this breakdown made a complicated law feel a little clearer, consider subscribing to Compliance Decoded. We turn dense regulation into plain English so you can stay ahead of the deadlines that matter. And we'd genuinely like to hear from you. Which rule or region should we explain next? Drop it in the comments, and we'll add it to the list. Educational overview only, not legal or compliance advice. Consult a qualified professional for your situation.